ASG Luncheon, we're going to have two speakers. First, I want to introduce Tim Baxter from the New York Local Group. He's going to discuss our favorite subjects on SEC rules and regs. And then our keynote speaker, Dave Gourevitch of the law firm of Dave Gourevitch. He'll follow Jim. So with that, Jim, the podium is yours.
I will not tell funny stories at all because of popular demand from Jerry and I just want to briefly point out that in the American Bar Association law review that goes out to all the business lawyers every quarter, the lead article in the May 2012 edition of the Business Lawyer is a 50-page article summarizing an academic study of SEC enforcement decisions and policy. It was written by a professor at Berkeley Law School. It was funded by a foundation at Harvard Law School. This is the first systematic study of SEC enforcement for the last 30 years. The study concludes that there is a clear bias against small broker dealers. It's what you all know, but this gets the numbers and confirms that in the decision making of how to go after the enforcement, the SEC systematically is lighter on the big firms than the small broker dealers. For example, whether they go after individuals or just the company, as far as this is concerned. For the big firms, 40% of all of the enforcement actions are against the corporation only. For small broker dealers, only 10% are brought against the corporation only. This is I think, a very interesting article, which Emily is going to send a copy of this article to everyone at NIBA, so that you can have a copy. And if you want to send it to your or you're a senator, that's up to you. And I think it's something that the regulators, the Financial Services Committee of the House and the Senate Banking Committee should be aware and should think about this in terms of implications for the SEC. Thanks.
Good afternoon, ladies and gentlemen. Can you hear me in the back of the room? Great.
Can we be quiet, please? Thank you. Take it away.
Thank you. I want to actually commend the article to you that Jim mentioned. It's about SEC enforcement, and it's an academic piece that says what I think everybody who's here from this has known for a long time, which is that the SEC takes a much harder view and much more aggressive position with the community that's right here in this room, with these small broker dealers, small issuers, than it does in giant companies. I think this is something that everybody here who works in this area has known intuitively and by experience, but the article lends an academic in terms of work, and so when you see it, it's worth reading. My topic is emerging enforcement trends critical to broker-dealers, small-cap offer issuers, and offerings. And this is pretty much what I do. I came out of the SEC, and I came out of the NIBA's office. I've been in private practice. And most of my work is devoted to defense of regulatory and white-collar investigations. And so I'm here. I wanted to thank the board and NIBA, and Emily in particular, for inviting me this afternoon and to address you about this. This is the most heavily regulated industry in the United States. And so it's simply a fact of all of our lives that part of what we do. And what I'd like to talk a little bit about is sort of the rules of safe living. I'd like to talk about what the regulators are focusing on and what you need to know about what they're doing to raise the money safely and compliance. So before I turn to what the current trends are, I'd like to sort of give a broader historical perspective. This has changed a great deal over the last 20 years. Prior to, say, 1995, 1996, there was relatively little regulatory enforcement. It was uncommon. There were no criminal broker-dealer cases. But starting in the mid-90s, there was a huge space of regulatory and criminal cases focusing on small firms and small issuers on issues of misrepresentation, of disclosure, of risk, compensation, play, all sorts of things. And these investigations, this trend, sort of peaked in the very late 90s and then ended with the market collapse in 2001. And then in 01 and 02 through roughly 05, we saw a rise, actually, of cases that did involve large firms. And these were the market timing cases, pay-to-play, the analyst cases that state regulators typically brought, not the SEC. These were areas and places where Baxter and took the lead, and the SEC generally followed. And those went through roughly 05 and 06. And then for the last 5 or 6 years, roughly 05 through 010, there was a real dearth of regulatory enforcement. Really, the market sort of hit the bottom, hit the skids. Enforcement also came way down. But that has changed in the last 2 years. And I want to tell you that since 2010, the SEC, FINRA, and the Justice Department are focusing very much on small offerings, small broker-dealers, these kinds of reverse merchants. And these are the hot areas for enforcement. In the last year, we've seen a somewhat different trend. Congress is taking the initiative and is now lowering the barriers to raising money in this country. So I wanted to sort of start there, but I also really wanted to sort of address a particular kinds of questions that you and the audience may have. So if you do, please feel free to jump in and ask. You don't need to wait until the end. You need to speak a little loudly. This is a large, deep room, and I may repeat questions, but please feel free to ask what you'd like to ask about. At the last NIBA conference, it was focused about crowdfunding, and I wanted to touch on it very briefly. As you know, it came in the Jobs Act, Title III. And crowdfunding, the rules of which are still yet to be announced, allows for essentially mass marketing of offerings up to $1 million. It's subject to 3 critical limitations. It's a limitation of $1 million per year. It's a limitation on the amount that any one investor can invest, split currently by whether the investor has a net worth or income of more than $100,000. But if they have an income or net worth of more than $100,000 in its current structure, they can invest up to 10% of that income or net worth, which is a fairly substantial figure. And the third deals with the portal provider. This was an area that I think when this was originally proposed generated tremendous interest. There was a lot of interest in creating portal providers and using portal providers to market these small offerings. The SEC last month or earlier this month came out with their initial approach to it. And what it says ultimately is that that the portal providers are going to have to be registered with the SEC, which is going to be a fairly large hurdle. We have to check what that hurdle is. And if they are non-broker dealers, they can't provide investment advice or make recommendations, solicit the purchase or sale of securities, compensate employees for doing so, and handle investor funds. So all in all, I think it makes the portal providers sort of less attractive because there are limitations on what you can do, and you do have to register. So where I see the sort of crowdfunding evolving is to something akin to a 504 offering of $1 million or less that can be done through a general solicitation, but most of these are going to end up through broker dealers. And it's going to be particularly through small and mid-sized broker dealers, large broker dealers. The wirehouses of the world, I don't think, are by and large going to get involved with crowdfunding and forks. The second, and what I believe is going to be the more significant change in rules is the elimination of the general solicitation provision. As you know, when you solicit private placement, general solicitations in the past have not been permitted. The rule was that the broker-dealer or the institution person marketing had to have a prior relationship with the person that they're soliciting. On August 29th, the SEC proposed amendments to this, to 506 of Reg D, to eliminate this prohibition on general soliciting and advertising, subject to two key conditions. And these are important. This is going to really change the way that money can be raised for small issues. It says that the purchasers of the offering must be accredited, and that the issuer of the broker-dealer has to take quote-unquote reasonable steps to verify that the purchaser's status as being truly an accredited investor. Sort of referred to something as crowdfunding for the applicant. Essentially, it looks like crowdfunding, but it can only be for accredited investors. The most burdensome aspect is that the issuer of the broker-dealer doesn't have to take reasonable steps to verify. Like all things that tend to be reasonable under the law, reasonableness is in the eye of the beholder. But what the SEC has already said is that it is more than the investor filling out a form and checking the box. That will not work. Fill out a solicitation form saying that it's going to involve something in the nature of additional diligence. And it says you can rely on W-2s, tax returns, or average compensation for comparably situated vehicles. I'm not sure how you find that out, but that's the kind of thing that they're looking for. If the minimum investment is sufficiently large, they say that you can rely in part on that, on the theory that nobody without not an accredited investor would put up a minimum, say $200,000. You can delegate or outsource the verification requirements to third parties to do attorneys. And that's the mistake. And I think that's a lot of and what is reasonable is also on methods of solicitation. There's a very broad solicitation, where there's almost a crowdfunding type of solicitation. The expectation for verification on the issuer and on the broker-dealer is higher than where your market is, say, database of investors. The SEC has yet to come out with the regulations. It probably will do so for a good 3 to 9 months. And you can't do these things until it comes out with the regulations. And they've taken the trouble to emphasize the number of crowd portal fundings have already appeared. So at the same time, we see the SEC largely under pressure from Congress as lowering the obstacles to raising capital. The SEC itself and FINRA are also bringing back a large number of cases in this area. And you can see it over the last 2 years, starting in 2010, when the SEC formed a group. They formed 2 groups. One was for market surveillance, and the second was essentially to focus on market abuse. And there have been a large number of these cases, and the topics that they're focusing on, probably everybody knows who read the paper. The first of them is reverse mergers. And I want to read you briefly a statement. It comes out, reverse mergers are legal. They've been around. The SEC has had opportunities to prohibit them, and it's never taken them up. But notwithstanding that, I think it's fair to say that there's a hostility to reverse mergers within the SEC. And this is for a press release that came out fairly recently against, among others, one of the packagers of shell companies. And the associate director of the SEC office in New York said shell packagers buying for public companies by fraudsters have no rightful place on market. What I read is while you can see the caveat that says for use by fraudsters, shell packagers really don't know too much in buying shells. What it really reflects is simply a regulatory hostility merger to the practice of selling shell companies and to all of the associated. And that's what you're seeing is coming out of the Office of Market Intelligence and the Market Abuse Unit. There's been a focus, as you've seen, on China reverse mergers to the point where I would say it's basically shut the business down, and you don't see too many new reverse mergers in these cases. Many of these cases are also being done as parallel criminal investigations. The SEC in the past had focused in some cases, they focused on the broker dealers, and they focused on the issuers. But that aspect of things is now changing. And you can call this different things. The SEC has talked about gatekeepers, about the people who are gatekeepers for issuers to the marketplace. You talk, the other way to look at it is people who are vendors, service providers to issuers and to the broker dealers. But there are a marked increase in cases in people who are providing shells, transfer agents, attorneys, and accountants. So the typical, the long historic focus of these cases is kind of broadened very significantly to everybody in the area, and it does not take a lot to pull on these investigations. The other areas that you'll see is that the DTC, which controls whether they can trade, also joined in this, and it's made it difficult to investigate that where they have questions about security, they are chilling or freezing the trading in the market, stock can't freeze trading in the market. There's also an uptick in insider trading cases, and hedge funds and private equity cases focusing on valuation and SPV. At the same time, in the FINRA, which regulates the broker dealers, you're also seeing the same phenomenon. In 2010, FINRA came out with rules about special due diligence requirements on broker dealers for private placements, and it's limited to private placements and direct appointments in that size. And it says essentially that they are bringing a lot of cases in this area, and it focuses on what the expectations of the FINRA are of due diligence. But it says that at a minimum, the broker dealer is supposed to conduct reasonable due diligence about the issuer and management, the business prospects, the assets held by and acquired by the issuer, claims made, and the intended use of the proceeds. And this means essentially that for the broker dealers, they can't simply rely on what's in private placement. They have to go beyond it. And if there are red flags, if there are signs that maybe there are problems, you have to go even further. And FINRA says that there's these red flags, you can't even rely on the financial statements. You have to go beyond the financial statements and really get tired and make sure that they're accurate. And the standard for what red flags are always in situations of practice that they're the eyes of the beholder. But they're relatively vague and broad. And one of the red flags that FINRA has cited is a refusal to provide information to the broker-dealer, the provision of incomplete information, or the provision of outdated information. So So it sets a low threshold for the point at which FINRA is requiring broker-dealers to do or super due diligence. More recently, this past spring, they've also changed suitability rules in what is Rule 2311 and Notice Number 1225. FINRA is moving, would like to regulate not just broker-dealers and registered representatives, but I think it also would like to represent the investment advisory. Investment advisors have historically been notified of a different standard, fiduciary standard than broker-dealers. In these rulings that came out in May and June, the interpretive guidance, the SEC, the FINRA, took a large step toward a fiduciary standard. And you can say that they were adopting a fiduciary standard, determined that the broker, the registered rep, the broker-dealer have to act in the best interest of the customer. And the best interest standard is the language ultimately of the fiduciary standard. So I think you're going to be looking at more cases that are going to be brought based on recommendations and due diligence involving private placement. The other two areas that are hot are the mini-max offerings, where FINRA in particular, and to a lesser extent the SEC, are focusing on the details of how the offering is conducted, whether an escrow is set up, whether the escrow was broken prior to the close, the receipt of the minimum under the escrow, whether the minimum was in fact reached, and whether, oddly enough, if the terms of the offering are changed in the middle of the offering, whether the money was returned to investors and they were given a new chance to reinvest it and make a decision again. And these cases are being brought not as sort of mistakes or errors in the way the mini-max offering is done, but as fraud cases. So there's a difference between sort of a mistake, an error, and a fraud case is now being conflated into one and the same. The final area of finder's fees, and there's a lot of focus on the area of finder's fees. As you know, generally speaking, you have to be an associated person or registered rep to receive a finder's fee. There are limited exceptions, but the SEC is looking at deals involving finder's fees, and they're looking at them in two areas. One, they're looking at the registration issues. Secondly, more importantly, they're looking at the substance of the deals, and not so much in the small cap area, but most recently in the area involving trading of privately held social media stocks. There's been a couple of cases in Florida, New York, and Washington, where people have bought and sold the stocks, and it turns out not entirely legitimate. Those are the areas that I see, but I see that for the next year or two, we're going to be living in an environment in which there are new opportunities to raise money, that the obstacles and the barriers are coming down, but that there's going to be constant and intense scrutiny about the way it is done. If you all have any questions, I'd be delighted to answer them. Yes? Just speak really loud.
I have two questions.
That's great.
I think listening to you is those of us who are in the micro-cap area are ready to jump out of a window.
Well, don't do that.
I won't do that, but I think correctly, at any time since 1932 when the SEC was formed, somebody looking at the regulations in that particular area and environment could recite a very grim situation, which would it be as grim as the situation you just portrayed? Maybe, I think, that's my question. And you'd want to jump out the window. You'd be so discouraged. In any era, in the past 70, 80 years since the SEC, President Roosevelt put that into the name with Joseph Kennedy heading up. First, is this particular environment that you just recited really any different than what you could have recited 5, 10, 15, 20, 30 years ago, 80 years ago, if you looked at the regulations as they were at that time? That's my first question. My second question is, if Governor Romney becomes President of the United States, he's obviously had some experience with Bain Capital, of the microcap, getting a small little company and 2 guys in a garage with a fast chip or something and making a lot of money out of it. He knows this area very well, no personal experience. The president, probably anybody else running, doesn't know the microcap area for years. Therefore, do you think if you had a man like Romney in there, understanding the situation, living in his own life, making money with it, that the president can come in and change the whole thing and make all this, as you said, go away by something or other, or is it too embedded in the fabric of the SEC and the government bureaucracy? 2 questions, a long question.
Let me see if I can repeat them. Back. The first, I think, suggests that I painted so much for the picture, which I really haven't been to do.
Oh, I understand.
The rules, substantively, haven't changed. The rules, actually, are the same as it existed since 1934. What changes and what goes up and down, I think, is sort of the enforcement approach. And I don't believe that this is, I think, frankly, in the late 90s, there was sort of a much more zealous approach. I think that in the time period of sort of 02 to 06, where you actually saw competition between state regulators and law enforcement, federal regulators and law enforcement were in the cases. I think it was a much more dangerous environment. What I'm suggesting here is what I think is intuitive to people here, which is that not unlike the business prospects of the small cap offering, the regulatory environment today is one great opportunity because the barriers are coming down. The elimination of the general solicitation focus is a large important change. But it's also one in which there's a great deal of risk, and I think that what you're doing is going to be second guessed to some extent. And all I'm saying simply is sort of be careful. Be careful out there. Yes, sir. Oh, the second question was about Romney.
Well, it's not only Romney, but can any president like Romney who understand this president, I don't think has a clue in this area, and the others mentioned, can the president, by fiat or something, change this whole attitude, or is it too embedded, ingrained in the bureaucracy?
I think the tone is set at the top. I think that in a sort of trickle-down approach, that the president does set the regulatory tone. But ironically, I would tell you that I believe that there has been more aggressive and zealous enforcement under Republican administrations than under Democratic.
Really?
Yeah. Sir?
Yeah, going back to the crowdfunding, you talked about 10% of the net worth. Is that a maximum of $10,000? Or is it 10% of their entire net worth for their investment?
It is.
You repeat the question?
Yeah. The question is, most broadly put, how does, in crowdfunding, there's a cap on the amount that an individual investor can invest in a particular offering. And the question is sort of, how does it work? As it is currently structured, with the rules yet to come, it's structured in a 2-tiered way. If your income and net worth, or net worth, are less than $100,000, it is functionally capital, I believe, $5,000, or 5% of your income and net worth. If it is over, it is 5%, I believe, or 10% of your income or net worth. And as I understand it, there is not currently a cap. What I'm saying, at least as I understand it, is potentially fairly high.
All right, 2 quick questions. You said that portals have to be registered. If you're a broker-dealer, do you have to register also, or you have to register?
Trader has to decide that.
And the second question is, what is your expectation on timing of these rules being implemented? And what is that?
The two questions were whether if you're a portal provider and a broker-dealer, whether you have to be separately registered as a portal provider. It hasn't been decided. At least as I read the release that came out, it suggested that you had to be registered as a portal provider if you were not a broker-dealer, but it was far from clear. I mean, it was done in a two-way fashion, and it was elliptical. In terms of the timing, the SEC is behind track. They were supposed to have this done already. It's not uncommon for them to be slow, not just in promulgating regulations, but in most respects. In terms of when they're going to have it done, I really wouldn't hazard a guess. I have no comfort that I can tell you that it will be done by the end of the year. Sir.
Does anyone view what you're speaking of in terms of the SEC simply trying to cut down on low-volume S1s, low-volume shareholder S1 filers?
I didn't understand.
If they're moving the number up to do private placements from 500 shareholders to 2,000, is that correct?
Yes.
Okay. Does anyone view that as a de facto methodology of reducing the number of low-volume S1s for people who have 600 shareholders by the SEC?
The short answer is yes. In other words, if you don't have to register if you have 600 shareholders, you're not going to register. I think that there's sort of a gradual awareness that the registration reporting that has existed for 70 years has really not kept pace with an information age where information is more, greater visibility and much quicker. That a quarterly and annual reporting system that has one system is not keeping pace with the times, but there is no real decision as to where to move throughout. Any other questions? Thank you very much.
Hi, I'm Michael Scillia. Doug, are you still here? Just finish that question and stay out. Last week, Joe Price said that FINRA was deciding on Doug's question. FINRA has not decided yet whether it's going to be an SRO for portals that are owned or affiliated with broker-dealers. They haven't made that decision. And right now, you're supposed to be making comments to them, official comments, to recommend ways they should or shouldn't do that. I'm Michael Scillia. I'm on your board of directors, and I'm also in charge of the regulatory committee. And we had a couple of very exciting things happen in the last couple of months that we wanted to share with you. First of all, the advertising and general distribution, the comments are due for that right now. I had the pleasure of witnessing firsthand the open committee meeting on the 29th, and I can tell you 4 of the, excluding Mayor and Shapiro, the other 4 commissioners, of course Aguilar voted against it, the other 3 commissioners who voted for it, excluding Mary, 5 commissioners, did not want to vote for it. They voted for it because it's so late, and they did not want to delay it because it was going to comments. So you need to make your comments. NIBA will be making comments on your behalf as well. But those comments are important, and I hasten to tell you, they are reading every single comment. Why do I know that? Because I was there and saw them firsthand. And this coming Monday, which is very exciting to us, the SEC invited us, little old NIBA, to come in, and 4 other organizations, RISA, IPA, TNDDA, and FSX. We're representing them, so we're going in with 885 brokerage firms on Monday morning, and we are going to be discussing the broker-dealer financial responsibility rules and the comments of 31 pages of the 153-page proposal they wrote back in 2007. We are also going to be discussing the Regulation A changes. I'll cover that real briefly, real quick. We are proposing, Congress mandated that Reg A's would go from 5 to 50 million. Now let's face it, guys. When was the last time any of you did an OTC bulletin board 10 to $50 million offering? Nobody does that. Oh, come on. That was institutional offering.
30 million.
Pardon me?
30 million.
30 million BB? Non-institutional?
Yeah, some institutional, most of retail. Everything's right.
My point is, there was only 5 of them done in the last 5 years. That's what was done. So it's the most least used of all registrations. It should be used. So we are proposing, and we're the only prescriptive proposals that the SEC received, which is why they invited us to come. We're proposing that Reg A gets broken down into 2 categories, which Congress has provided for. One is going to continue to be an exemption from registration form that's going to be a little more strict on who cannot use it. We don't want the bad actors to be able to use it, which they like. The other, for those of you that remember SB2s, we're going to propose the second portion of Reg A is going to be a short form registration statement, which will allow up to $50 million offerings that the New York Stock Exchange market and the NASDAQ will allow a coincidental payday registration for listing purposes. As you know, Reg A cannot be used to list a stock. So this way, we have a short form, firm commitment of best efforts registration statement that would be filed with the SEC, much less than an S1, that would be listable on an exchange. The SEC is interested in discussing that. Both exchanges are interested because they're suffering, they don't have enough listings. They want to get listings. Ever since SB2s went out, their listings went down 60%. This was, I've been in the business 39 years, and I can tell you it was 12 years ago when Joe Marks was invited, who was chairman of NIBA years ago. The last time we were invited to do this was 12 years ago when Joe Marks was chairman. So it's a kind of once in over a decade. The most important thing we're going to be talking about in the SEC, however, is the broker-dealer financial responsibility rules, the 153 pages. There are 5 provisions in the broker-dealer financial responsibility rules which will raise your net capital requirements by as little as $330,000 for a nickel BD to as much as $2 million for a $100,000 BD, depending on the nature of your business. These are serious proposals. They are not backing off on them. We had about 5 two-hour conversations with staff at the SEC that are writing the rules. I can tell you they're not backing off on these general proposals. There are nickel BDs that, based upon what they've spent over the last 3 years, that their rule is proposing that from the first quarter of the year, based on 3 years average, they're going to make you accrue what they think they're going to spend over the next year. What that means is you have to carry between 80 and 100% of that capital every month as you do it. So if you spend $500,000 and you had an 80% requirement, you'd have to have an additional $400,000 in capital on your books on March 31st under March 31st voters, even if you're a $5,000 BD. I don't have to tell you how much that's going to cost you. I don't have to tell you how many Bs aren't going to want to do that or can't do that. It's a real rule, and there's nobody else fighting it. SIFMA doesn't care about small broker-dealers. They're fighting the big rule. The ABA doesn't care about the small broker-dealers. They're fighting another rule. NIBA is the only organization in tandem with RESET, the NDDA, the IPA, and FSX that is supporting this initiative, which combined are about 1,200 broker-dealers. Only 1,500 broker-dealers are licensed to do small private placements or non-registered best efforts deals. Only about 450 of not counting the big guys, the 178 large firms. Of the small and medium-sized broker dealers, there's less than 500 now that can do underwritings, registered underwriting. There were over 2,000 10 years ago. So we think this has been very exciting that we've been able to get this done. I'm very anxious for this meeting on Monday, and I would like to hear from any of you between now and the time we leave tomorrow afternoon. If any of you would like to come up to me and give me a note or have a conversation about things you'd like to know. Our comments were filed with the SEC on all these things, Reg A's and everything. You can find it on the Reg A on the SEC's website under comments filed. But I think it might be on the NIBA website too, I'm not sure. I think our comments are filed on the NIBA.org website. Thank you very much.